just touch upon it. Nothing today is meant to be in great depth. Really, this is sports law 101, so to speak, but it's really not just law. And I don't like the term 101 because there's a lot here that's much broader and much more involved than that. I mentioned the Jeremy Bloom case earlier, and that's just an excellent case to look into. You guys can Google this stuff to death, and you'll find out about Jeremy Bloom. But his case against the NCAA is one that I really do encourage you to look into. You find fascinating. Another one is the Maurice Claret case. Maurice was a running back at Ohio State University, an unbelievable one. And after his freshman year, in which the Ohio State University won the national championship, he wanted to play in the NFL. And the NFL said, no. You have to be 3 years removed from high school to play in the NFL. The NFL had its own regulation, preventing him from pursuing a career as a professional football player. That was a lawsuit that Maurice Claret lost. And great case to look into. It's very interesting that Maurice Claret's agent was Josh Lukes. And Josh wrote a book that all of you might find interesting. If you want to read about what it's like to be a sports agent, read the book Confessions of an Agent by Josh Lukes, L-U-C-H-S. Josh happened to work at ProTech Management in Los Angeles. And the owner of ProTech was Gary Richard. I played freshman lacrosse with Gary Richard at CW Post College. And guy who had more guts than any quarterback I've ever seen in my life. Back in those days, we used hickory sticks, and he'd get beaten on and kept going and kept going. And amazing individual, extremely competitive, as you have to be. And, pardon me, but anyway, there's also a case that you'll find where Josh Lukes was in the news recently. So some of you actually may have read it. If you read Sports Illustrated, you read about Josh Lukes revealing what happened when he was working for Gary Richard, all the things he did as an agent. Gary Richard, by the way, unfortunately passed away just a couple of months ago from pancreatic cancer, and his entire management company has been disbanded. He represented numerous athletes over the years. Gary had graduated from CW Coast College in Long Island. He was a quarterback and was drafted by the Baltimore Colts. Didn't make the team, but he played in the East-West All-Star Shrine game, and then from there went on to become a sports agent. Well, how did it all happen? How did Gary the way it happened was when Gary went and played in this All-Star game out west, he met a guy by the name of Brian, he was a linebacker at the University of Oklahoma. And anyway, he met this one guy, and from that one meeting, he asked him to be his agent, and that's how he started his entire business that spanned over 35 years, just from meeting one person. So when people ask me often, how do I become a sports agent, the answer is get a client, because that's the only way you're going to get there is to find a client and then move from there. And that client, and as you know, as I've told you now, can come from anywhere. And when I think about just how I personally cultivated clients, I like to talk about how, as a lawyer, again we talk about soliciting. You want to represent a client, you can represent a client as a lawyer, you can represent them as an agent, and I suggest to you that if you're going to do it out of one house as a lawyer, that you have to constantly look at the ethical considerations. A lot of these lawsuits that I think I'd like to just go back to, what happens with some of these athletes, and what are you dealing with when you're representing an athlete? Is it an amateur? Is it a professional? Well, the answer is it's hard to tell. There is a lawsuit right now that all of you should be aware of. You might want to follow along, because I think it's going to be one of the most interesting lawsuits ever against the NCAA. It's a class action suit, and the name of it is O'Banion v. NCAA. That's O''BANNON. Ed O'Banion played basketball at UCLA in the mid-90s. He was outstanding. He went on and played professionally, and he was a phenomenal player at UCLA. Years later, he happened to meet up with a guy, and the short of this story is that he found out that Electronic Arts, company that makes these various sports games, was using his likeness and image in their game. And he wasn't getting any money. And he walked into a showroom one day where he worked in a car dealership. The guy says, "How much are you getting for that?" He goes, "For what?" He goes, "For that game that you're in." He goes, "What game I'm in?" "What are you talking about?" And then he found out that his number looked just like him in this game. And why wasn't he getting any money? Well, just for your information, Electronic Arts was making $400 million a year on that game. You know how they got that money? You know how they got the rights to it? The NCAA. That's who gave them the rights. So, how the NCAA get the rights to use Ed O'Banion's likeness and image? And the answer is, if you look at the materials, I provided a copy of the student athlete statement, the NCAA Division I statement. That's what you have to fill out for. That's what you have to fill out in order to compete at NCAA schools. When you compete at an NCAA institution, let me make some points here. First of all, the NCAA is a voluntary membership organization. You don't have to go to an NCAA school. If you want to compete in a sport in an NCAA school, you have to go by their rules. All they have to provide, just like the interscholastic associations in each state, and just like the United States Olympic Committee, is procedural due process. That's it. That's all they have to provide. So it's a hearing, essentially. Now, when you play at the NCAA school, you sign away your rights, you find out that it's a big number when you're someone like Ed O'Banion. I'm going to refer you to Section 4 of the NCAA student statement that you got. It's the Form 10-3A, provided in your materials. It's pretty interesting because when you essentially play for the NCAA school, you've signed away, according to their rules, all the rights to likeness and image. So that means the NCAA is making all the money. Ed O'Banion is making nothing. And there is now a huge movement afoot, including very good lawyers from all over the country who are supporting this O'Banion case, and I'm one of them. Because Ed O'Banion's likeness and image is being sold by the NCAA for the good of the NCAA, and the NCAA would tell you, yeah, but we disperse this money to all these schools, to all these athletes, and all these sports. But Ed O'Banion's getting nothing. Years and years later, he's getting zero. So now this has become a class action lawsuit. This lawsuit could change everything. This could be the game changer, and it should be, in my view. That's why I kind of started off just before the end of the break, saying the litigators in here have to really hone in on this, because you can play a very important role. And when you get involved with sports, you can play a very important role. You just have to know where you're going and what you're doing before you take the action, because filing a legal action or counseling a client could really end up impacting them in many different ways. The O'Banion case, for information, is currently in process out in California, Northern District of California. And you should be hearing more about it in the news. I think that the real key here is the intellectual property rights. You see from the outline that I put together over these years how different aspects of law impact amateur and professional athletes. Remember that with the amateurs, they're not supposed to enter certain conflicts. That's kind of, that's changed a lot over the years because at one time I represented happened to be a friend of mine from Georgetown who won the 1976 Boston Marathon. In 1977, when I was coming out of law school, he asked me to be his agent. I was not his lawyer. I was his agent. And after he came in third in the race in 77, but I happened to be around a few of the very best known marathoners in the world. And at that time, right after the race that night when we were talking, I remember it was pretty interesting. One of them, Bill Rogers, said, "Boy, you know, they're talking about broadcasting the marathon next year on CBS." And we all, if you follow the Boston Marathon now or the New York Marathon, so many years later, it's obviously a whole different show today. But back then, they were all supposed to be amateurs. They couldn't be professionals that they could be today. Well, that's what really should be happening with the college basketball players and particularly football players who are making all this money for the NCAA and for all the other athletes. I think it's a great time. There's nobody in this room I can guarantee who's more of a supporter of student athletes than I am, and more interested in students being able to compete in athletics in college, not lose their scholarships, and have all of the benefits of athletic competition. But I think it's unfortunate that over the years I've seen other sports progress, but the NCAA has not allowed to happen what I think the O'Banion case could create, which is more parity for those individuals through their talent who make so much money for so many institutions. I know I digress a lot, and the reason is because there's so many things to talk about that impact one thing and another. You look at the Uniform Athlete Agent Act. Why did it come about? I was in Florida when, in fact, when I was writing the article that's in there about athletic eligibility, that year they were thinking about trying to get an Athlete Agent Act in place in Florida for agents to register. Obviously, because so many agents were invading high schools in Florida to get baseball players right out of high schools, and there was no protection. Guess what, by the way? If you look at the Athlete Agent Act, or if you look at the article that you have in your materials when I wrote about the Florida Athlete Agent Registration Law back in 1988, no protection for the high school athletes, it's only for the college athletes. So that's kind of interesting. But the key was, the reason why we had to have that law come into effect was not just the athletes. It was the money that the colleges would make. Florida State University, who were notable professors behind the Athlete Agent Registration Law with me, as I pushed for it, was that Florida State made an enormous amount of money from its bowl appearances and its football television rights. And they were concerned that a violation from the NCAA would shut that down, shut that off, and cause big problems for their universities. So no matter what we talk about here, it's all going to come down to money again, one way or the other. That's how, in Florida, the athlete agent registration came along, and that's why it's across the board in other states. It's really to also protect the institution and all the money that's at stake when they lose their television rights. Once again, I go back to what I learned from the Harvard Symposium this past March. Two things. Football is where it's at. Litigators are going to be the ones that change sports law. That's true. So, the real problem I have with the NCAA's grant and aid scholarship is that the athletes are giving away their likeness and image rights. The O'Banion case is the one to look out for that. If you're going to get involved with athletes, if there's one area of law that you should be aware of, that you should really study hard, that you should review, and that is so important, obvious, that it's contract. When I represented about a dozen women professional golfers, my role was not just negotiating contracts with agreements, deals with sponsors, clothing companies, golf club companies, personal appearances at events. No matter what I was involved with, we had contracts involved. And I ran into this ethical problem again, where here I'm the agent, and I have a management agreement with the player, but I'm going to be drafting the contract. Now, if I'm drafting a contract, am I drafting the contract as a lawyer or as an agent? So I made it very clear in my agreements that they can get any lawyer they want for their contract. I'll do the deal. They can get whatever lawyer. But if they want me, they have to, of course, sign off on it that they had their choice, that they chose that I do it, and then I had to hire my law firm, my professional association, to do the contract. If you don't do that, again, we're in this conflict here. A little bit of a difficult situation. What are you, lawyer or agent or both? And I think through the proper agreement and looking carefully at the ethical rules that apply to you in your role, you can be both. That's where the term that I use today as a sports lawyer, where I am. I'm a sports lawyer because I can be both an agent and I can be a lawyer. I can counsel, but I am not restricted from being able to charge a percentage of a player's endorsements or a set fee for negotiating a contract or drafting the contract, as long as you're covered ethically, separating out all the pieces. I can tell you that in New York, it's a piece of cake compared to Florida. That's the shit. Sometimes people think that when you're going to operate as an agent of a professional athlete, you're a lawyer, that all you're really doing is negotiating deals. Well, you're not. You have a lot of responsibilities to that individual, and they include financial services, tax planning, estate planning. You have to plan for their career after sports, what happens to them. So, I like to talk about how I was with the accountant for Kenny Anderson, a basketball player from Georgia Tech that played for the New Jersey Nets. Anybody here know who Kenny Anderson was? Well, a few people do. He's a heck of a guy, I can tell you that. I happened to be with his accountant I met his accountant through a transaction, and he asked me to go to a game, and I'm sitting watching the Nets play over in the Meadowlands, and I just remember him saying to me, "Oh, Kenny's doing great." This was his rookie year, by the way, 93 or 4, something like that. And he said, "Kenny, going to get a $70 million contract." Can you believe it? They're going to give him $70 million 5-year contract next year. I said, "That's great, man. That's great. And how much do you have him insured for?" I said, "Well, insured? What do you mean?" I said, "Well, he's going to be worth $70 million. So, I mean, what kind of disability do you have?" I said, "What are you talking about?" I said, "Well, who's his agent?" He told me his agent was this guy I knew down in Atlanta. And I said to him, "Are you telling me that he's not insured for anything, any disability?" "No." He said, "Okay, would you do that? Would you have it?" I said, "Well, first of all, in my view, the agent has committed an error. It's an omission, actually. If you've got an athlete that can make $70 million, and if he happens to trip over that plate on the floor and falls and he can't play basketball anymore, he just lost $70 million. I know who I would sue, and it wouldn't be the player. And he was shocked. I said, you're shocked? Just think if he was a lawyer who did it. That raised a lot of issues. And folks, if I digress and I go from one thing to another, it's because we're dealing with the broad spectrum here. I want you to start to think a little bit about what you do. If you're a lawyer and you're involved with an athlete, ethically, the question is, are you giving a professional service or are you in a business? I mean, this is, the practice of law is still a profession in which, though there are business considerations when you run your law practice, your obligations as a lawyer run not just to your client and to yourself, but clearly to the profession. And you have certain obligations that you have to abide by, not just ethically then, but under your malpractice policy. Look at your malpractice policy and see if it covers business advice if you're an agent to an athlete. I can tell you that I come from an insurance family, and I can tell you that I haven't seen a malpractice, that is, attorney's professional malpractice policy, that covers advising a professional athlete when you're their agent. And so, in this particular case, I said, with Kenny Anderson, if Kenny had gotten injured and his career was over, his agent was on the line. But if that agent happened to be Richard Fraley in Florida at that time, my position, and Richard and I disagreed on some of these things, but I can tell you that my position would be, Richard, you're a lawyer, you hold yourself out as a lawyer, your firm signed a contract with him, you're giving business advice, and you didn't advise him. So now the question is it just an omission? Is it malpractice policy even cover it? These are the kinds of things that get very deep and involved. And if any of you want me to do just a course on nothing but something like representing a professional athlete, professional football player, something of that sort, I'll get into those issues in much more depth. Because as the years have gone by, of course, there's a lot more that's happened with the league contracts, whether it be the National Football League, the National Basketball Association, NHL, on and on. They all have certain requirements. And, of course, one of the things I should mention, it's really strange. This is, I think, one of the oddest things about the uniform athlete agent law. It does not require, and typically it is not required, that you have insurance, that you have errors and omissions insurance. And one of the reasons why they did not include it is because it varied so much from state to state. So if you ever get involved in representing athletes, I suggest you look very careful at that fact. You're going to need to cover yourself in the event you don't cover the athlete. Something that I will allude to now also with the NCAA, I really do want to do a course on just the NCAA. In fact, I want to do more than one. There's so much to talk about. The NCAA has a provision where the athlete, and you might say, well, let's say that an athlete came to you and one of the counsel, can you advise an NCAA athlete on the law? And what law can you advise them on? I won't go into it in any depth now. But what I will tell you, and what is very clear, is that athlete could have, let's take Maurice Clarett that I mentioned at Ohio State as a freshman. If he could have entered the NFL draft, which they wouldn't let him do, he would have been worth a fortune. If he wanted a disability policy, the NCAA will allow it, but only if it's total disability. In other words, the athlete can only be covered for a disability that would make him completely 100% disabled, not partially disabled. That is a real issue for me and for a lot of people because it's almost not allowing them to have it.